Hello and welcome again to another edition of SEN Unplugged. My name is Mark Small. Today we're going to talk about admissions for children who have special educational needs and education, health and care plans. Now, the important thing to bear in mind is that all children, by law, whether they have SEN or not, are required to be educated in mainstream schools. And thus mainstream education cannot be denied because a child or young person has a special need or a disability. And if an admissions authority were shown to be refusing admission based on that fact, then that could bring about a claim under the Equality Act. For children who have education, health and care plans, the local authority again has a presumption of placing the child within a mainstream school, unless parents say they want a special school, or it can be shown that the child's attendance in a mainstream school is incompatible with the efficient education of other children. Now, by law, that is an extremely high threshold to have to satisfy, and mainstream education cannot be refused on the basis of suitability or a lack of resources. It can only be refused because the child's difficulties are such that they will prejudice the education of other children. And if a local authority is going to refuse that mainstream preference, then they have to have compelling evidence to justify that decision. Where a child has an education, health and care plan, parents have a right to express preferences for schools when it's issued in draft format and at subsequent annual reviews. Under Section 38 of the Children and Families Act, parents have the right to be able to express preferences for a range of settings, including state schools, which includes mainstream primary, mainstream secondary, special schools, academies and free schools, institutions that are within the further education sector, non-maintained special schools, and institutions approved by the Secretary of State under Section 41 of the Children and Families Act. Now, all of those different types of schools attract what's called a statutory preference. Now, the reason why that's important is that the local authority is required to consult with those settings when you express a preference, and it will have to consult in writing with the admissions authority for the school, which may be the governing body or the proprietor of the school. And it has to name one of those schools unless some statutory exceptions apply, which we'll look at in a moment. Parents can also make representations for schools not on that list under Section 9 of the Education Act, and the local authority has to have regard to those representations and will have to consider whether naming the setting gives rise to the efficient training of the young person or the child, or reasonable public expenditure. So what do you do when you express preferences? Well, it's always best to have a number of preferences up your sleeve, if you like, when you get your draft plan, and to make those preferences known to the local authority in writing. The local authority, once they receive your preference, must consult with them. And as I said earlier, if it's a statutory preference, it has to name that setting unless the setting can demonstrate in its response to the consultation that it's unsuitable, taking into account the child's age, ability, aptitude or special need, that the attendance of the child or the young person is incompatible with either the provision of efficient education of the other children or the efficient use of the local authority's resources. Now, the burden of proof falls on the local authority to be able to prove that those exceptions apply. Now, in reality, what that means is, once the consultation process has been completed, they will receive a written response from the admissions body, and they will have to decide whether the reasons given are sufficient in circumstances where the admissions body says we can't offer the child a place. Now, one of the key things, just in terms of timescales here, the admissions authority for the institution has 15 days, that's 15 calendar days, to respond to consultations. And if a setting refuses to respond within that timescale, then the local authority is at liberty to name that setting without further recourse to the admissions authority. And that's quite important. When the local authority consults with the institution, it sends them a copy of the Education, Health and Care Plan and the appendices, and perhaps the latest annual review. The admissions authority has 15 days to respond to the consultation process and to set out its response in writing. And as parents, you should request a copy of the consultation response from the local authority, as you are entitled to have a copy. Because if the local authority refuses to name your preferred setting, then you have the right to know the reasons why. And that is the case regardless of whether the preference is made under the statutory schools that I've identified or under Section 9 of the Education Act. The other thing just to bear in mind, if the school is a maintained school, the local authority has to consult with the local authority in whose area the school is situated, because that local authority is technically the admissions authority for the school in the case of maintained schools. Academies and free schools and Section 41 approved schools and non-maintained special schools are their own admissions authority, and won't share any responses with the host local authority, if you like. Once the consultation response is returned to the local authority, it's the decision of the local authority to name the setting. The local authority also has the power to name a setting where parents fail to express preferences or make representations for an educational setting, and they have the power to name any other school or institution depending on the age of the young person. It's also important to bear in mind as well that the local authority, when they're consulting with schools, does not necessarily need to have parental consent if they want to consult with schools not proposed by the parent or carer. So they're at liberty to have quite an extensive consultation process if that's what they want to do. Once the responses are back in, the local authority looks at the reasons given. If the decision is yes, then obviously that goes no further, and the local authority will just have to have regard to whether it's going to be named. If it's no, then the local authority may challenge the reasons that are given and will give the admissions authority a further period of time to provide a response. But this is the important point. When the setting is named in Section I and it's a statutory preference school, the governing body, proprietor or principal of that school is required to admit the child or the young person. So that they cannot oppose the admission even if they disagree with the decision. That doesn't apply to those settings where the representations are made under Section 9 of the Education Act. And for those types of settings, they're generally going to be the non-approved independent schools. That will be a matter for the independent school to decide if they're going to offer places or not. So if you're going to express preferences for independent schools, then it's important to have an offer of place available at the time that you make your representations to the local authority. We deal with quite a lot of admissions type disputes. And some of the common issues I think that are relevant for parents just to be careful of are things like this. The local authority refuses your preference on the basis that the school is full. That is not a reason to refuse your preference. The local authority says perhaps your child's needs can be met in mainstream school when you've expressed a preference for a special school. Again, that's not a reason to refuse your preference. So if you're getting rejections when you've expressed preferences for schools, then the key thing to do is to be able to seek some legal advice to see if you've got grounds to challenge it, because you can appeal to the SEN tribunal where the local authority refuses to name your school of preference. And that includes the statutory preference schools and also the independent schools under Section 9 where you have a confirmed offer of place. And if your appeal is only against Section I, in other words, you're happy with the rest of the Education, Health and Care Plan, then you don't need to obtain a mediation certificate. Although you can still go through the mediation process if you think that the matter could be resolved in dialogue with the local authority. And it's always important to think about mediation given the cost and the stress that may be associated with going through an SEN tribunal. Some things to think about when you're looking at schools. It's always a good idea when if you're thinking about expressing preferences for settings, to get copies of school prospectuses, look at their Ofsted report, and arrange visits to the setting. You're at liberty to make appointments to go and meet the SENCO and have a look around. See the school in its natural light, if you like. Look at the peer group that your child could be educated with. Ask questions about the resources that they have available to them. Look at the specific provision in your child's education, health and care plan and see if it can be provided by the educational setting. And these are important things to do when you go round the school, so that you've got enough information to decide whether it's going to be suitable and appropriate for your child. The other thing I think as well to be clear of, don't be intimidated by the local authority. If they do refuse your preference, then use your right of appeal. You can challenge that decision, and it's important to bear in mind that in the majority of appeals that go to the SEN tribunal, local authorities lose 90% of them, and a high percentage of those appeals concern placement disputes in respect of Section I. So don't fear the appeal process. In fact, in most cases that I encounter, the local authority has failed to properly discharge its duties under these sections by failing to properly consult and failing to properly respond to the parental preference. So certainly don't be put off appealing because the local authority simply says, we're not going to allocate you a place, it's full, a place isn't going to be available. Ultimately, it could be a decision for an SEN tribunal whether your child is admitted into the school or not, and the tribunal can order the school in an EHC plan whether the local authority or the admissions authority agrees to it or not. So we've set out there for you the process by which you can express preferences for educational settings and the kinds of things you have to think about when the local authority is consulting with settings and making a decision on placements. Further information can be found on the SEN4U website, where we have a leaflet specifically on admissions and some frequently asked questions around admissions. As always, if you like the video, comment, subscribe, like, share, and we've got more videos coming soon. You've been watching SEN4U Unplugged. I'm Mark Small. Let's make SEN great again.